Assalamu alaikum. Today is the 20th of August, year 2024, and myself, the advocate Gulraiz Ashfaq. I would like to describe my written law, the executive judicial written law, which I would be online conferencing to the public at large, that it should be upheld in the Parliament or in the Senate through my video linkage, because I observed that the public would not understand these focal issues. So why I construe this law, named as an act to provide the permanent relief to the life of the vulnerable groups of the females of the Pakistan, year 2020. I had written this law during the year 2020 and it is the year 2024. And after this achievement, I had written the law, an act to prohibit the family victimization. Number 3, an act to control the family politics. Number 4, an act to prohibit the blood relation marriages. These 4 consecutive laws of mine, which I just delivered and have all copyrights material by myself, that's why I had written these laws. During the year 2016 towards year 2024, I had observed the females' issues in the Pakistan, and a lot of the females are suffering out of the vulnerable civil family marital disorders in the Pakistan, along with the factors of the property challenges and the rent issues, the civil manipulative type of the constitutional issues in the Pakistan. So these laws are interchangeable. While if any female which becomes a targeted tool in the central limits of the Pakistan, if file a petition according to my written law, if it be passed by the Parliament or the Senate, thereafter such aggrieved female will be compensated by the state institutions at the will of the statutory bodies of the Pakistan, as per my observation. But if any female which becomes a manipulated tool in the Pakistan, and such female do not have a sufficient source of reliance regarding the custodial matters of her children, the defection children, I have found a lot of the children issues in the Pakistan. The primary baseline issues are interconnected with the narcotic over-processed groups of the females in Pakistan, as per my findings, that such females, after finding that their males are not providing the sufficient reliant sources to them, becomes a subject of constitutional controversial mediums, and such females do not find the substitute point of reliance to living parameters under the Islamic Sharia, under the Islamic laws, and the social values could be observed in the declinations to said females in questions. And after observing such devastating positions of females, or such females want to have the social penetrations of the income and expenses, but such females do not have a sufficient reliance of sources, and thereafter such females becomes a central victim of deprivation of the rights of the civil liberty, as well as the freedom of speech, along with the factors of the freedom of expression in the public sector. And while observing such laws, I have observed that it is a prevailing constructive effective law which is not declining after observing the females' rights in the Pakistan, that a lot of the females do not have even being compensated as a humanitarian laws or under the humanitarian rights. The humanitarian rights, the females find themselves very inconvenient as to compile the best narrative observations regarding their male-dominant societies in Pakistan, and such females do not have a sufficient ways as to execute the life of the said females in question under the Islamic Sharia. And thereafter, a lot of the females which becomes the secondary thought could be observed as the divorcee repatriation factors in the Pakistan could be observed in the Pakistan, and in the India and the Middle East, a lot of the females become subjected to of the divorcee repatriation, along with the factors of the females' child production growth. And it is a prevailing third factor that the females do not have the sufficient resources as to originate the wealth for the child of someone else, from whom such females bequeath constructive divorces. In Pakistan, it is also a custom in precedent which is not declining so far in the upper judiciary as well. I'm talking about the custom and precedent in the judicial department in Pakistan, and thereafter, when I observe that the confinement of the females, the wrongful confinement in the marital resolutions, it is another destitution type of offense which is not being observed by the Republicans, that whether they have provided the sufficient resources to the females after having conjugal relationship with such females in fact or not. This is a landmark judicial question and standing one which should be addressed to the Republicans. They have to construe such factors which are leading the females in the wrong decorum of executions in the public sector, and such females do not find themselves in reliance with the compensations to the civil defection areas for their better future, and as to reconcile the recovery to the civil laws. In Pakistan, it is very difficult as to construe a law regarding the females in defection areas, and I find that when I have written the law, an act to provide the permanent relief to the life of the vulnerable groups of the females in Pakistan, that 2020, after observing the positions of the females' declinations in the public sector, I was bound as to rotate such law, and thereafter either the parliamentarian or the senators are not interested as to construe such laws, because they are themselves suffering from the economical disorders in the public departments, and especially the public administrative departments or organs in Pakistan, functional leagues, and they are just harassing each other, and they do not consider my laws so far, and they do not have the second option as well. So they never consider the females to be a point of living. So the females should have considered these laws before it's too late. Stay blessed with most comparative constitutional advocate Gulraiz King.